Hello everyone, and welcome to the third episode of Let's Talk About It. I'm your host, Darryl, and I want to take you on a short journey back to my home city of St. Louis, Missouri. More specifically, the first historically black town settled in Missouri, which is the city of Kinloch. Now, before doing so, let's do some general historical education. So for decades, the city of Kinloch suffered neglect and various forms of criminality at the hands of sitting mayors and various government officials. So, because of this history, on February 26th of 2015, the Board of Aldermen for the city of Kinloch passed ordinance number 20159, which states for the purpose of this report that any person engaging in conduct of moral turpitude and or any crime involving moral turpitude shall not acquire a position with the governmental body for the city of Kinloch by election or appointment. If the person is a current member of the governmental body when any such conduct is discovered and or determined, said person shall be subject to immediate impeachment. The definition for moral turpitude is an act of baseness, vileness, or depravity in the private and social duties which a man owes his fellow man or to society in general, contrary to the accepted and customary rule of right and duty between man and man. Everything done contrary to justice, honesty, modesty, and good morals. And the discipline shall be impeachment and may include criminal prosecution, civil action, or any action deemed necessary by the Board of Aldermen to deter such conduct in the future. And then the last portion of this ordinance indicates this ordinance shall be in full force and effect from and after the date of its passage. Any ordinance in conflict with this ordinance is hereby repealed. So that's ordinance 20159. The ordinance is a civil ordinance, does not require a criminal conviction. It only requires, through a preponderance of the evidence presented, that a person's pattern of behavior demonstrates their tendency for moral turpitude, or, in other words, to flout the rules and laws of society. As a side note, within the state of Missouri, there are 5 classes of felony and carry penalties accordingly. But for today's report, we're only going to refer to the Class D felony. Now, per former St. Louis Metropolitan Police Department Detective Benjamin Bender, some Class D felonies are or include third-degree domestic assault, resisting arrest, fraud, or passing a bad check. And a Class D felony in Missouri is punishable by up to 7 years in prison or 1 year in the county jail. And in Missouri, the Class D felonies are the next lowest class of felonies that one can be charged with. The courts can also impose a fine of up to $10,000 if you are found guilty of a Class D felony. Now, if you aren't trying to follow the law or generally accepted rules in particular of society, you may not want to throw your hat into the political arena. Why? Well, one reason for this is that when you do, there are documents that you must sign for any politically elected position in the state of Missouri, and more specifically, for this report, the mayoral candidacy in the city of Kinloch. This is Candidacy Form 5120, which is a notarized legal affidavit in which you swear or attest that certain information is true under penalty of a Class D felony charge if it turns out that what you swore about is untrue. Again, understand this. You're signing a legal document, an affidavit that's notarized saying, I swear that this is true and that I'm unaware of any other issue, okay? The issue is that at the time you sign the document, what you swear or swore was true or false. It's not whether you plan to address the issue in order to make the statement true. It's whether it was true at the moment you signed it, the date that you signed it and had it notarized. So, in April of 2019, the city of Kinloch held the election for mayoral and other elected offices, but this report is specifically regarding the position of mayor. Now, in any political contest, you'll have a candidacy qualification verification process. That means for wherever it is, there's a city clerk or county clerk that has to verify that you meet certain qualifications, okay? The first step of this process includes what the person running must provide. In this case, that's the declaration document 5120 that I referred to before, which is now on your screen. Take a moment. The second is a background check. And the third is a check for tax delinquency with the state of Missouri's Department of Revenue. Now, again, this is just to educate you on the process of running for office and the requirements, just in case you may decide you want to throw your hat into the arena. Now, early in March of 2019, Mr. Darryl Williams submitted his declaration as a write-in candidate for the mayor of the city of Kinloch. And some of this has been covered in a previous video, and it'll be notated in the notes below this video. But I'll provide you with a quick recap. At the time, March 11, 2019, Mr. Williams signed the notarized affidavit document 5120 to be a write-in candidate for the office of mayor of the city of Kinloch. You see that on your screen. The sitting City of Kinloch city clerk, the election official, performed a candidacy qualification verification process and determined that Mr. Williams was ineligible for office because at the time she received his information declaring himself as a candidate, he was found to have 4 years worth of outstanding personal property taxes, and at that time was being sought after for an active warrant for a traffic violation that he never took care of in court. So the city clerk sent the notification to the St. Louis County Election Board, or the Board of Election of Commissioners, and notified them, according to this document, that he was ineligible to be a write-in candidate under revised Missouri Statute 115306, which states, "I hereby declare under penalties of perjury that I am not currently aware of any delinquency in the filing or payment of any state income taxes, personal property taxes, municipal taxes, or real property taxes on the place of residence as stated on my declaration of candidacy." Now, explain to me how one can be delinquent on not 1, not 2, not 3, but 4 years of personal property taxes and not know. You have to renew your automobile tags on your vehicle each year or every 2 years in the state of Missouri. Without paying said personal property taxes, you can't renew the tags on your vehicle. Should you pay someone under the table in order to get those tags so that you appear to be driving with valid tags, this still implies that you are aware of and are trying to skirt around the system. Bottom line, there's no way to stand on the idea that you did not know. Hence the problem for Mr. Williams. The fact is that at the time he signed this document, he was willfully and falsely making an affidavit statement under penalty of perjury. He was knowingly furnishing false information to an election authority or election official engaged in their lawful duty or action in such a way as to hinder or mislead the authority or official in the performance of official duties. Basically, Mr. Williams committed fraud by submitting a false affirmation statement to an election official. Revised Missouri Statute, Chapter 115.631 says a Class 1 election offense provides that offenses shall be Class 1 election offenses and are deemed felonies connected with the exercise of the right of suffrage. A person is guilty of the conduct if willfully and falsely making any certificate, affidavit, or statement required to be made pursuant to any provision of this chapter, including but not limited to statements specifically required to be made under penalty of perjury, or in any other manner knowingly furnishing false information to an election authority or election official engaged in any lawful duty or action in such a way as to hinder or mislead the authority or official in the performance of official duties. If an individual willfully and falsely makes any certificate, affidavit, or statement required to be made under Section 115.155, including but not limited to statements specifically required to be made under penalty of perjury, such individual shall be guilty of a Class D felony. And let's talk about 115.405, which is a false swearing a Class 1 offense. Any person making a sworn statement, affidavit, or declaration of candidacy required by this subchapter who swears falsely or signs such document knowing the statements therein are untrue shall be deemed guilty, shall be deemed guilty of a Class 1 election offense. Again, the issue is, at the time you signed the document, you were aware that you were making a false declaration. Now, also, Mr. Williams, at the time of submitting his certification for candidacy, was also a fugitive of the law for criminal misdemeanor traffic matters. This issue went all the way back to December of 2016, and the charges were operating a motor vehicle without financial responsibility, meaning he didn't have insurance on the vehicle he was operating. And also, he was driving while he was under a suspended or revoked license. And because he had repetitively failed to appear and address this minor traffic matter, a warrant had been issued for his arrest on January 3rd, 2018 by Municipal Judge Sean James O'Hagan. Now, since the warrant was issued more than a year prior to his candidacy declaration, it's a tad bit difficult to believe that Mr. Williams was unaware that this particular issue was happening. More importantly, he was aware that he had been issued a ticket and he knew that he had not been to court to take care of it prior to signing the document 5120. And everyone knows in the city and counties of St. Louis, if you failed up here for a traffic ticket, an appearance being by you directly or by counsel, that a warrant will be issued for your arrest. However, even if you dismiss the traffic violation and warrant being issued, you cannot dismiss the false affirmation that he made on Form 5120. In order to do so, you'd have to be claiming that he was mentally deficient in some manner. And why would you want a mentally deficient person sitting as the mayor? Anyway, let us keep in mind, Mr. Williams has resided in the city of Kinloch for many years. I would estimate for more than a decade. He had been and still is residing at the address on the file that he documented for his 5120. Now, of course, we're not going to show that address because we don't believe in doxing, but to believe that you're unaware of your outstanding tax debt for this number of years is somewhat laughable. Ever heard the saying, nothing in life is certain but death and taxes? Well, personal property taxes are included in that statement. Why? Mr. Williams was delinquent on personal property taxes for multiple years. It is safe to assume, without evidence presented to the contrary, that Mr. Williams had received multiple notifications from the Department of Revenue regarding his delinquent taxes at the address of record. That is, the initial tax assessment each year, the follow-up notification when it has not been taken care of by the indicated due date, and then a follow-up notification once it fell into delinquent status. That is a minimum of 3 notifications each year to the same address on file for the individual in question. As of March 2019, at the minimum per public policy and procedures of the Missouri Department of Revenue, there were a minimum of probably 12 notifications sent to the address on record for Mr. Williams. So, Mr. Williams was delinquent regarding personal property taxes for years 2015, 2016, 2017, and 2018. This, fact 1, which made Mr. Williams ineligible to participate for mayoral election under Missouri Revised Statute 115.306. It is common knowledge in the state of Missouri that if you own personal property, you owe personal property taxes. Car, truck, motorcycle, SUV, RV, etc. They're all considered personal property. Now, we must also make note that Mr. Darryl Williams is currently delinquent on his 2019 and 2021 personal property taxes as well. So, when the election occurred, Darryl Williams was declared by the St. Louis County Board of Elections as the winner of said contest. Herein, we turn to revised Missouri Statute 115.306, which states a failure to comply may disqualify you from the ballot. Why is this information being noted? This is for your education. Mr. Williams was disqualified from participation based on Ordinance 20159, which is an ordinance to protect the city of Kinloch and her citizens against conduct and/or crimes involving moral turpitude. You can go back to the beginning of this presentation and listen to the first few minutes to refresh yourself about moral turpitude. Needless to say, Mr. Williams was suspended by the Board of Aldermen, and in May of 2019, he was blocked from sitting as mayor of the city of Kinloch through impeachment. The former articles of impeachment were issued to Mr. Williams on site at City of Kinloch City Hall on April 19, 2019. And as a matter of record, during the impeachment process on May 17, 2019, the administrative proceeding held by the City of Kinloch Board of Aldermen, which is the hearing where you are given an opportunity to dispute the articles. Mr. Williams offered no evidence disputing the articles of impeachment. This is a matter of fact based on the record from the impeachment hearing. Mr. Williams never offered any testimony disputing the articles of impeachment. One article was regarding the false affirmation he made on Form 5120. The sitting Board of Aldermen, the jury, during his impeachment provided him a hard copy of the record and their rendered decision on May 24, 2019. This date's important, and we'll come back to it. And I'll reiterate, your impeachment hearing is a civil procedure and not subject to the same beyond a reasonable doubt standard as a criminal court, meaning you don't have to be found guilty of a criminal act as you do in the court of law. It only has to be demonstrated as a matter any reasonable person would reach that you've committed the acts indicated. The pattern of behavior exhibited in the case against him demonstrated a certain level of baseness. If you sit idle, offer no defense, nothing to contradict what is presented against you, then it is understandable and reasonable that those sitting in judgment may assume all evidence supporting said articles, or at least supporting one article presented against you, is true. And you don't have to be found guilty of all articles of impeachment in order for you to be impeached. You only need to be found guilty of one. In this case, the administrative jury found him guilty on all three counts unanimously. On the record, the judge presiding over the impeachment hearing informed Mr. Williams about his option to submit a request for a judicial review if he disagreed with the outcome, and that said petition must be submitted within 30 days of the rendering of the verdict by the jury, and said petition could be filed in the circuit court. Again, this all took place on May 17, 2019. Now, Mr. Williams decided that he didn't get a fair shake by the City of Kinloch Board of Aldermen in his impeachment hearing. You know, the one that allows him to refute the articles of impeachment where he refused to provide any evidence or testimony. So, Mr. Williams took his issue to the Missouri Circuit Court, Division 21, for what is termed a judicial review. And the case was eventually heard by Judge Nancy Watkins McLaughlin. Now, before I move into the judge's ruling, let's talk about what the judge's duties are in a judicial review. So the judge is supposed to be an impartial referee between two parties. The judge's duty is to review the record of the matter and the supporting evidence. After reviewing this information, the judge either accepts the ruling or overturns said ruling. This is supposed to be impartial. This also must be filed within a limited time frame from the time the ruling was submitted. That means the petition to that judge is only supposed to be accepted if it is submitted within the 30 days from the time the ruling was issued and the documentation was submitted to the petitioner. That's 30 days from the receipt of the original ruling documentation, the administrative conclusion. The judge should not argue on behalf of either party. The judge should not testify in place of either party. When you bring a matter up for judicial review before a judge, you can only submit into evidence the record being reviewed. That is the impeachment hearing record. This record is supposed to be submitted by the petitioner at the time they submit their request to the courts. You can only cite for review objections made during the hearing that you may believe were not properly considered. Mr. Williams did not submit his request for judicial review until well beyond the time frame allotted to request a judicial review, beyond the 30 days. They also that would be him and his counsel, did not submit the documentation, which is the impeachment hearing record with the petition, which is also against the judicial review process and procedures. So, one, they provided no evidence to the court, and two, they filed it outside of the scope allotted for such a petition. And let me tell you, the judge then required the city of Kinloch to fulfill the burden that the petitioner was supposed to fulfill, which is a violation of the court's process and procedures. Nothing outside of this should be considered as evidence or facts if it is not presented, and nothing is presumed that is not included from either side. With that being said, we'll proceed. The purpose of the judicial review filed by the petitioner was to figure out if revised Missouri Statute 536.140 was violated, and there are rules governing the process of judicial review also. Missouri statute affords petitioner an opportunity for judicial review, but the petition must be filed within 30 days of receiving the record. Again, I reiterate, the impeachment vote was rendered on May 17th. The petitioner was personally served a copy of the impeachment documents with the Board of Aldermen's decision, along with each of the exhibits entered at the hearing. So that means that the deadline for submitting his petition for judicial review should have been somewhere around June 16, 2019. I would even go so far as to say June 18. Now, within the record, it was found that specific and credible evidence was presented during the impeachment hearing demonstrating that Williams was not qualified to run for mayor. This is the due process. You get to face the accuser and provide evidence refuting the claim. There was no challenge to the articles of impeachment by Williams during his hearing. He didn't bring counsel to his hearing. He's allowed to have counsel, but is not required to have it. Why he made no attempt to bring counsel is a matter for debate. He offered no cross-examination, direct examination, opening or closing statements. So, the petitioner, Mr. Darryl Williams, was present at his own impeachment hearing and offered no refutation of the articles of impeachment. Even when the Board of Aldermen indicated on the record that their decision was going to be to impeach him based on the evidence presented before them, Darryl Williams was present to hear and refute and did nothing. This is due process. However, the full record was also released to the petitioner's new attorney of record, Mr. Donnell Smith, on May 28th of 2019, electronically, meaning June 27th would be the new cutoff date for a judicial review. You could even go so far as to try to ignore Saturday and Sundays and push it back to July 8th, and you'd still be outside of the time allotted for a judicial review. The petitioner, Mr. Darryl Williams, and his counsel did not submit their petition for judicial review to the circuit court until July 15th, 2019. This is 18 days beyond the second submission to the petitioner's attorney of record. Again, I must state, compliance with the 30-day deadline in revised Missouri Statute 536.110 is a jurisdictional prerequisite to judicial review. So the judge, the Honorable Nancy Watkins McLaughlin, Circuit Court Judge Division 21, accepted the submission of a petition for judicial review well beyond the procedurally allotted time frame. The rule regarding the submission does not indicate any room for the court's discretion to decide to allow petitioner's request beyond the allotted time frame. She ignores the fact that according to the record, that the impeachment hearing transcripts, which were forwarded by the contestants, that's the city of Kinloch, upon her request, were not supplied by the petitioner as the court's rules require. The petitioner never raised any objection to the articles of impeachment during his hearing. The judge also offered what some may consider testimony on behalf of the petitioner by testifying in her ruling on his behalf. So, during the due process hearing of impeachment, the petitioner, Mr. Darryl Williams, offered no refuting evidence, testimony, or objection. Petitioner Darryl Williams does not dispute on the record whether or not he knew of the delinquent taxes, which implies that you knew. The time allotted by the rules governing judicial review had lapsed to the tune of an additional 30 plus 18 days, and thusly the petition should have been denied by the circuit court. And when the judge tenders her ruling, that's number 4, she testifies on behalf of the petitioner when she states on the record that the petitioner was unaware of the outstanding taxes, where Nowhere in the record does the petitioner indicate knowledge of or lack thereof knowledge, which implies that he knew. Suffice it to say, on or about December 28, 2021, the Honorable Judge Nancy Watkins McLaughlin overturned the City of Kinloch's Board of Aldermen impeachment and indicated that Mr. Darryl Williams is the mayor of the City of Kinloch. And on December 30th, Mr. Williams and his entourage live streamed their attempt, without prior notification, to enter the City of Kinloch City Hall building. Well, considering the staff and board of alderpersons were working remotely as a precaution due to the rise of COVID cases in the St. Louis metropolitan area, which includes the City of Kinloch, and around the country, of course the doors were locked. An appeal to the judge's ruling has been submitted by the City of Kinloch Board of Aldermen's Council. But once the judge rendered her ruling, the mayor fell back under the power of the City of Kinloch Board of Aldermen. Now, let's look at what ironically happened on January 6, 2022, the anniversary of the insurrection attempt in Washington, D.C. On January 6, Mr. Williams and his associates, with the assistance of a police captain, Mr. John Blake, broke into the City of Kinloch City Hall building, unplugged all of the cameras within the City Hall offices that they did not have the authority to enter, changed the locks, and then locked out the sitting legislative body, the Board of Alderpersons. Now, Police Captain Blake apparently left the premises once the locks had been changed. Now, this took place prior to Mr. Williams being confronted by staff from City of Kinloch City Hall and Board of Aldermen members. In the video, which was taken during the confrontation of Mr. Williams and his entourage, the cameraman clearly states, if you were paying attention earlier this morning, you watched as the new mayor, Darryl Williams, actually was able to gain access to this establishment, meaning that they actually live streamed the break-in. Said video has miraculously disappeared. However, only the latter confrontation was ironically live streamed on the Facebook page of the New Real STL News. Some of the individuals who broke into the building are believed to be as follows: Morella Smith, William Collier, Phyllis Queen Daltrey, and Otis Shanti Hughes, and several additional parties that have yet to be identified. But one can only reasonably suspect that all persons present at the time the building was breached and officers were intruded upon, and wherein all cameras were disconnected, that all the individuals present entered said building, which would make them all guilty or accessories to breaking and entering. Now, on this live stream, Mr. Williams was informed that the board had held an emergency meeting on January 3rd and issued a new suspension and impeachment procedures on January 4th. He is seen receiving the documents on the Facebook live stream. Later, in that same video, he is heard saying that he didn't want to accept the documents that he had already accepted. Now, he is currently sitting in arrears for personal property taxes from 2019 and 2020, and based on his track record, possibly 2021, which is still a violation of the 5120 affirmation and candidacy requirements. On top of this, Mr. Williams and his entourage, with the assistance of a law enforcement officer, committed breaking and entering and possibly an act of insurrection against the City of Kinloch's legislative body on January 6, 2022. How ironic is this? Now, it appears that the St. Louis County Police Department is refusing to comply with requests for the police report number for the incident on January 6, despite it being filmed and broadcast on Facebook Live. And despite the sensitive information breach that occurred when Mr. Williams and his entourage entered the secure offices and rummaged through various offices within City Hall. This is a federal crime and has to be reported to the appropriate authorities for investigation and possible federal criminal charges. So, we will wait to see what happens with the upcoming impeachment process. The request for the police report number from the incident on the grounds of the City of Kinloch City Hall, as well as the police captain who was present when the break-in occurred, and whether or not there will be any additional criminal charges filed in this case. We'll tell you about it as things develop in a future episode of Let's Talk About It. Thanks for watching.